A federal judge has ordered the administration to begin refunding billions of dollars in tariffs. More than 2,000 companies have filed lawsuits seeking refunds, according to reports, and many of them are big businesses like Costco and FedEx looking to benefit from the tariff challenges initiated by small businesses. The federal judge's order comes after the Supreme Court invalidated some of Trump's tariff powers last month. The order directs U.S. Customs and Border Protection to begin recalculating duties importers paid and determine exactly how much money needs to be returned. On top of returning tariffs paid, where estimates range from $130 billion upwards of $175 billion, the government revealed in a new court filing that it will also pay interest on the refunds, estimated to be nearly $700 million per month.
Hey everyone, Adam is here. So let's get started. The federal courts just ordered the immediate, unconditional release of up to $175 billion in tariff refunds. Not after a review period, not after appeals, right now. Start cutting the checks. This isn't a policy setback or a legal inconvenience. It's a fiscal asteroid striking the Treasury with zero warning. The courts ruled the tariffs were illegally collected. The money belongs back to the businesses that paid it.
A federal judge has ordered the administration to begin refunding $130 billion worth of tariffs. Lydia, who's been following the story. Okay, Lydia, how many companies have filed lawsuits to get their money back?
Stuart, thousands.
Thousands.
By counts, it's more than 2,000 companies that have filed their lawsuits, according to reports. We were talking about big business, Costco, FedEx, Pandora, and they're looking to benefit from the tariff challenges that were initiated. Remember, it was the small businesses who filed the lawsuits. Now the big businesses are lining up to get their money back as well. The judge's order is coming after the Supreme Court invalidated some of President Trump's tariff powers just last month. And this order directs U.S. Customs and Border Protection to begin recalculating duties that importers paid and determine how much money needs to be returned.
And the era of using emergency powers as a personal revenue mechanism is over. The bill came due, payable in full, no extensions. Let me be explicit about why this moment is so extraordinary, because the context of the legal fight that led to this ruling is essential to grasping the magnitude of the defeat. Over 1,000 companies, representing virtually every sector of the American economy, from manufacturing giants to small agricultural processors, had filed suit against the administration over these levies.
A growing number of companies are asking for their money back after the U.S. Supreme Court's ruling against the Trump administration's Liberation Day tariffs.
Wouldn't you think they would have put one sentence in there saying that keep the money or don't keep the money, right? I guess it has to get litigated for the next 2 years. So they write this.
So that is U.S. President Donald Trump commenting on what could happen to the estimated $175 billion in tariff refunds that apparently are up for grabs. On Thursday, Politico reported that, according to sources familiar, U.S. officials are brainstorming ways of trying to keep as much of that revenue as possible. For more on how this tariff refund process might play out. So this week, FedEx joined a list of more than 1,000 corporations that are now suing the U.S. government for tariff refunds. That expanded list includes Costco, Dyson, L'Oreal, and Prada. Most of those brands people will have in their house, maybe not the product.
They had been paying them for months. Billions upon billions of dollars had been extracted from their balance sheets and deposited into the coffers of the federal government. And then the Supreme Court of the United States spoke. The highest judicial authority in the land declared that those tariffs were illegal. They were unconstitutional in their application and unauthorized by the statutory framework the president had attempted to weaponize. And the most basic principle of law dictates that when the government collects money under a statute or executive action that is later ruled void, the government must give that money back. The nonpartisan budget analysts at Penn Wharton crunched the numbers and arrived at a staggering projection. The total liability facing the United States Treasury for these illegal collections sits at approximately $175 billion. That is the conservative estimate. That is the floor, not the ceiling. Depending on how the courts calculate accrued interest and how the claims process unfolds, that number could swell even higher. The administration, staring into the abyss of that liability, did what any large bureaucracy would do when faced with a catastrophic and unexpected expense. They asked for time. They petitioned the Federal Circuit Court for a 90-day administrative stay. They made the reasonable-sounding argument that processing refunds of this magnitude requires logistical preparation. They needed time to set up the payment systems, to verify the claims, to figure out the budgetary offsets, and to manage the cash flow implications. They were essentially asking the court for a 3-month pause to catch their breath and figure out how to pay the tab without causing a fiscal seizure. And the Federal Circuit Court looked at that request and issued a response that sent shockwaves through the West Wing. The answer was no. Not a qualified no. Not a maybe later no. An absolute, unequivocal, and unappealable no. The court's reasoning was as blunt as it was legally sound. You lost at the Supreme Court. The tariffs were illegal from their inception. The companies that paid them did so under protest and are legally entitled to the return of their property. The fact that the government finds it inconvenient to pay back $175 billion is not a valid legal basis for delaying justice. The court noted that these businesses have been operating under the weight of these unlawful taxes for months. They have had to adjust their supply chains, lay off workers, or absorb losses while the government held their capital hostage. They have filed their lawsuits, paid their legal fees, and followed every procedural rule in the book. Now, the court declared, they deserve immediate relief. The era of accommodating the executive branch's logistical challenges is over. You collected the money illegally, now you will return it. Start the process now. This is the shock move. Courts almost always grant these kinds of delays. They understand that government is a massive ship that turns slowly. They typically grant a grace period for implementation, but this time the judiciary sent an unmistakable signal. The patience of the courts has been exhausted. The benefit of the doubt has been revoked. You are being treated like any other litigant who lost a case. Pay up. And the panic that this ruling has induced within the administration is palpable because $175 billion is not a line item that can be easily absorbed. It is real money. It is a massive, unplanned hit to the federal balance sheet. This is money that the government does not have sitting in a segregated account waiting to be returned. That revenue was spent. It was commingled with general tax receipts and used to fund the day-to-day operations of the government. It paid for military salaries. It paid for infrastructure grants. It paid for the interest on the national debt. And now, the administration has to find that money again. They have to conjure $175 billion out of thin air at the precise moment when the fiscal pressures on the government are already reaching a breaking point. This is happening while the president is trying to secure funding for potential military escalations abroad. It is happening while the government is lurching toward another potential shutdown fight over homeland security appropriations. It is happening while the overall budget is stretched so thin that the seams are beginning to show. This ruling does not just hurt the president politically. It hurts him financially. It creates a fiscal crisis that compounds and amplifies every other crisis currently swirling around the administration. And it demonstrates, with the clarity of a bank statement, that the courts are absolutely finished with granting this president any form of leniency or procedural grace. But to view this tariff refund ruling in isolation is to miss the forest for the single, very large, and very expensive tree. This is merely one front in a brutal, week-long judicial offensive against the administration's entire policy portfolio. It is as if the entire federal judiciary, across multiple circuits and jurisdictions, convened an unspoken conference and decided that enough was enough. The floodgates of adverse rulings opened, and they did not discriminate by policy area. In the exact same week that the Federal Circuit ordered the immediate refund of tariff revenues, other courts were busy dismantling other pillars of the president's agenda. A federal court blocked the administration's attempt to deploy the National Guard into the state of California for the purpose of immigration enforcement. The court ruled that California is a sovereign state within the federal system, and that the executive branch cannot unilaterally inject federalized troops into a state's territory for domestic law enforcement purposes without the consent of that state's government. It was a stinging rebuke on the grounds of federalism and the limits of the Commander-in-Chief clause. Simultaneously, another court issued an injunction against the administration's effort to freeze hundreds of millions of dollars in federal funding allocated to Harvard University. The administration had attempted to leverage that funding as a cudgel to force changes to the university's so-called sanctuary campus policies. The judge in that case was unequivocal, describing the funding freeze as unconstitutional coercion. The government, the judge explained, cannot use the power of the purse as a weapon to force private institutions or state entities to comply with policy directives that are unrelated to the purpose of the funds themselves. It is a fundamental violation of the spending clause and due process. The judicial assault did not stop there. Another court halted the administration's attempt to utilize the Alien Enemies Act, an archaic statute dating back to the late 18th century, to deport individuals without providing them the due process hearings that modern immigration law requires. The court stated plainly that the nation is not in a declared state of war with the countries in question, and that this antiquated law does not provide a shortcut around the constitutional requirement of a fair hearing. And in a ruling that strikes at the heart of the president's desire to control the levers of economic power, a federal judge blocked the attempted firing of Federal Reserve Governor Lisa Cook. The president wanted her removed from the Board of Governors because her views on monetary policy did not align with his own, but the Federal Reserve was designed by Congress to be an independent body, insulated from the short-term political pressures of the White House. Governors serve fixed terms and can only be removed for cause, not for policy disagreements. The court enforced that statutory independence, telling the president that he cannot simply fire a Fed governor because he dislikes her votes on interest rates. 5 major policy defeats, tariffs, National Guard deployments, university funding, deportations, central bank independence, all delivered within a single brutal week. This is not a coincidence. This is a pattern. And the common thread running through every single one of these rulings is the judiciary's rejection of the president's theory of unlimited executive power. The president's response to this cascade of legal defeats has been as predictable as it has been unproductive. He has raged. He has taken to his digital platforms to attack the integrity of the judiciary. He has singled out Chief Justice John Roberts for particular scorn, labeling him a disgrace to the institution he leads. He has turned his fire on Justice Brett Kavanaugh, a man whose nomination he personally championed through one of the most contentious confirmation battles in modern history. The president has accused Kavanaugh of disloyalty and betrayal for daring to vote with the majority in the 6-3 tariff decision. He has claimed that the entire judicial branch is rigged against him, a deep state operation designed to thwart the will of the people. But this narrative collapses under the weight of the evidence. These are not the rulings of liberal activist judges in far-left districts. The Supreme Court decision that triggered the refund order was a 6-3 ruling. It was a solid, comfortable majority that included justices with impeccable conservative credentials. It included justices that Donald Trump himself placed on the bench. They did not rule against him because of partisan animus. They ruled against him because the law is clear. The Constitution vests the power to regulate commerce and set tariffs in the Congress of the United States. The president exceeded his delegated authority. He tried to use a national emergency statute designed for freezing the assets of hostile foreign powers as a vehicle for rewriting the global trade order, and the court, including his own appointees, said no. He is now paying the price. Literally. The president has vowed to find a workaround. He has threatened to impose new tariffs using different statutory authorities. He is reportedly scouring the United States Code for any legal lever he can pull. Perhaps Section 232 national security tariffs or Section 301 unfair trade practice penalties. He believes he can simply switch the legal justification and achieve the same economic outcome. But legal experts across the ideological spectrum are telling him good luck with that strategy. The Supreme Court's reasoning in the tariff case was not narrowly confined to the specific wording of the International Emergency Economic Powers Act. The court's opinion, authored by the Chief Justice, articulated a broader constitutional principle. The major questions doctrine requires that when the executive branch seeks to exercise power of vast economic and political significance, it must point to a clear and explicit statement from Congress authorizing that specific action. Ambiguous language in old statutes will not suffice. You cannot hide an elephant in a mouse hole. Trying a different statute to achieve the same sweeping unilateral tariff regime simply runs headfirst into the same constitutional wall. The courts will see the new scheme for what it is, a repackaging of the same illegal power grab, and they will strike it down again, likely with even greater speed and even sharper language. The president is trapped. The tariffs he boasted about at every rally, the ones he claimed would bring back the golden age of American manufacturing, the ones he said would make foreign nations tremble and fill the federal coffers, are gone. They have been struck down. They have been declared illegal. And the financial hangover from that failed policy experiment is a $175 billion refund obligation that cannot be delayed, cannot be appealed, and cannot be escaped. Let us dissect the anatomy of this specific Federal Circuit ruling, because the procedural details are where the true shock resides. When the Supreme Court issued its landmark ruling declaring the global tariff regime unlawful, it opened the floodgates for over 1,000 corporate plaintiffs who had been seeking relief. These companies had been paying these import taxes under protest for months, in some cases for over a year. The money had already been transferred to the Treasury. The Supreme Court's decision retroactively confirmed that those payments were made pursuant to an unconstitutional executive action. Under the settled principles of American law, specifically the Tucker Act and related jurisdictional statutes, the government is obligated to provide refunds for taxes and duties that are collected illegally. The Penn-Wharton budget model, a widely respected and non-ideological research center, undertook the massive task of estimating the total exposure. By analyzing the volume of trade affected, the tariff rates applied, and the duration of the collection period, they arrived at the figure of $175 billion. This is not a political talking point. This is an actuarial estimate of the minimum amount the government is legally obligated to repay. The administration, recognizing the sheer administrative and fiscal chaos that such a sudden, massive outflow of cash would create, sought a reprieve. Their lawyers appeared before the Federal Circuit and requested a 90-day stay of the refund mandate. They argued that the Treasury needed time to stand up the processing infrastructure, to verify the legitimacy of individual claims, and to manage the significant impact on the government's cash flow and debt management operations. In almost any other context, this would be viewed as a reasonable and prudent request. The government is not a vending machine that can instantly spit out change for $100 billion, but the Federal Circuit denied the motion with a sharpness that surprised even veteran court watchers. The panel's order effectively stated that the government's lack of preparedness was not a justification for further delay. The court emphasized that the tariffs had been challenged from the very beginning. The administration was on notice from the day the first lawsuit was filed that this revenue stream was legally precarious. They chose to continue collecting the money regardless. They chose to spend the money regardless. And now, having lost on the merits in the highest court in the land, they cannot turn around and plead administrative inconvenience as a reason to hold on to the plaintiff's money for another quarter of a year. The court ordered the lower tribunals, specifically the Court of International Trade, to begin processing the claims immediately. There would be no global pause. There would be no breathing room. The process of unwinding the tariff revenue stream would begin right now. This is the shock move. It is a judicial rebuke not just of the policy, but of the administration's entire approach to litigation and compliance. It signals a fundamental shift in the judiciary's demeanor. The era of deference and accommodation is over. The courts are now in enforcement mode. And consider the political and fiscal landscape into which this ruling has landed. The president is simultaneously attempting to project strength on the international stage, including preparing for potential military actions that carry price tags in the tens or hundreds of billions of dollars. The Pentagon has already submitted requests for supplemental funding. The national debt continues its inexorable climb past previously unimaginable thresholds. The annual appropriations process on Capitol Hill is a perpetual knife fight, with the constant threat of a government shutdown looming over every deadline. And into this volatile fiscal mixture, the courts have just dropped a $175 billion mandatory expenditure. This is not a discretionary item that can be negotiated or delayed. It is a court-ordered liability. The money must be found. The administration is now scrambling to identify offsets. Will they propose cuts to defense spending at a time of heightened global tension? That is a political non-starter for the president's base and for hawkish members of Congress. Will they propose cuts to entitlement programs like Social Security and Medicare? That is political suicide in an election year. Will they attempt to borrow the entire amount, adding another massive layer to the already bloated federal deficit? That would expose the administration to charges of fiscal hypocrisy from both the left and the right. There is no good option. Every path forward is strewn with political landmines, and the Federal Circuit has just made it clear that the administration does not have the luxury of time to figure it out. They must start paying immediately. This financial crisis directly undermines the central economic message of the president's political career. He has long claimed that tariffs are a revenue-generating machine. He has told his supporters that foreign nations are footing the bill. He has argued that these levies strengthen the Treasury and provide the fiscal space for tax cuts and spending programs. And now, the Supreme Court has ruled that the entire scheme was illegal, and the Treasury is not receiving a windfall. It is writing a refund check for an amount that exceeds the annual budget of many federal departments. The narrative is shattered. The trade war was not a victory. It was an unconstitutional overreach that is now costing the government a fortune. Democrats and opposition researchers are already drafting the campaign advertisements. They will feature the number prominently: $175 billion. They will remind voters that this is the cost of the president's illegal power grab. And the president's only defense is to attack the judges who ruled against him, including the very judges he personally appointed to the bench. The broader pattern of judicial losses during this same period is equally devastating. The ruling on the California National Guard deployment is a significant check on the president's ability to use military assets for domestic political purposes. The court reaffirmed the principle that state sovereignty, protected by the 10th Amendment and the militia clauses of the Constitution, limits the federal government's ability to commandeer state forces or deploy federal troops onto state soil over the objection of the governor. The administration had sought to use the Guard as an immigration enforcement tool, but the court made it clear that such deployments require either a state request, a specific statutory authorization from Congress, or an imminent threat that meets a very high legal bar. The Harvard funding freeze case is similarly important for the precedent it sets regarding executive spending power. The Impoundment Control Act and the broader constitutional structure prevent the president from simply refusing to spend money that Congress has appropriated. By attempting to cut off funding to a university over a policy dispute regarding immigration enforcement, the administration was trying to use the power of the purse as a regulatory weapon. The court correctly identified this as unconstitutional coercion. The federal government can attach conditions to grants, but those conditions must be related to the purpose of the grant itself. Using unrelated funding as leverage to force changes in campus policing policies violates the clear terms of the spending clause. The Alien Enemies Act ruling continues a long line of cases where courts have pushed back against the administration's attempts to circumvent standard due process protections in the immigration system. The law in question was passed in 1798 during the Quasi-War with France. It permits the president to detain and deport nationals of enemy nations during a declared war or when an invasion has occurred. The administration attempted to apply this law broadly to migrants from countries with which the United States is not at war. The court ruled that this was a blatant misreading of the statute and that the administration could not use a centuries-old wartime relic to bypass the procedural safeguards built into the Immigration and Nationality Act. And the Lisa Cook firing block is perhaps the most direct limitation on the president's desire for total control. The Federal Reserve's independence is a cornerstone of the modern global economy. Markets rely on the assurance that monetary policy will be set based on economic data, not the political whims of the White House. The president's attempt to remove a sitting governor simply because he disagreed with her views on interest rates was an attack on that independence. The court's swift rejection of that attempt reinforces the statutory protections that shield the Fed from political interference. All of these losses occurring in a compressed time frame reveal a judiciary that is no longer willing to give this president the benefit of the doubt. The courts are applying the law strictly. They are reading statutes narrowly when it comes to claims of executive power. They are insisting on compliance with the Administrative Procedure Act, and they are doing so with a speed and a uniformity that suggests a deep institutional concern about the direction of the executive branch. The president's reaction, a visceral attack on the integrity of judges like Roberts and Kavanaugh, only serves to highlight his powerlessness in the face of these rulings. He can tweet about them, he can hold rallies and complain about them, but he cannot change them, he cannot fire them, he cannot appeal a 6-3 Supreme Court decision. He is stuck, and the $175 billion refund order is the most tangible and painful manifestation of that powerlessness. Here's the bottom line. The Federal Circuit's shock move refusing to delay tariff refunds has created an immediate fiscal crisis for the administration. They must find $175 billion, money that has already been spent, to pay back companies that were illegally taxed. This is happening in the same week that courts blocked the president on National Guard deployments, university funding freezes, deportation procedures, and the firing of a Federal Reserve official. The cumulative weight of these judicial defeats represents a comprehensive rejection of the president's theory of executive power. The courts, including justices he appointed, are telling him that the Constitution does not grant him a blank check. The era of tariffs is over. The era of refunds has begun, and the administration has been given no time to figure out how to survive the transition. The checks must be cut, the money must flow, and the political and fiscal fallout is only just beginning.